to the court. We have some continued negotiations. I did send a mitigation report for review by the prosecution. We're asking for, her next pretrial is set for February 25th, 12th. I understand that the court can't go out that far. I do.
Well, that's in 15th.
Correct.
But as I'm reading this, you're trying to track that case.
We are trying to track the cases together too, just to see what's going on in terms of mental health treatment, Your Honor.
Okay, back up a second.
Sure.
And Kingsley for a while. Is she in mental health court there?
She is not. She is getting mental health treatment, however, outside of the court.
Got it. And so that's, correct me if I'm wrong, that's being monitored kind of with the 15th District Court case.
That is my understanding.
And you're trying to follow along with some of that information regarding this case.
That's correct, Your Honor.
So why wouldn't I put it out after?
I would be asking for you to. I just didn't know if the court would do that for me.
You know, Bellinger, sometimes you just have to ask, but you always just ask for the wrong stuff.
Oh,
All right, this one I would do. This is not a problem. All right, so
Then we're asking.
okay.
what?
Then we're asking.
She got
Well,
this.
I know. Mr. Kingsley would ask me. I just don't know why you did.
I was trying. I was gonna get there.
Quit taking the scenic route. So your next date in 15th to the 12th?
Yes, sir.
All right. So let's go then, so you can figure that out. I won't go to the next date. Let's go to February 20th, given those circumstances.
Thank you, Your Honor.
Honor.
February 20th, 2025, 9 a.m.
There you go.
I'll do that for Miss Kingsley.
Thank you.
Right? Yes. Happy New Year. Court calls the case, People versus Eric Mayfield.
Your Honor, Alexis Pluma, Assistant Public Defender, appearing with and on behalf of Mr. Mayfield. Mr. Mayfield, could you say your full name? Your Honor, we are asking for an adjournment here. I would just ask for 2 weeks.
Without objection, January 16, 2025, 9 a.m. bond continue.
Thank you, Your Honor.
No, just. Court calls the case, People versus Corey Miller.
It appears so.
Assistant Public Defender Ben Dunawith on behalf of Mr. Miller, who should be in the Zoom meeting.
Here, I think he is. Mr. Miller, state your name, please, sir.
Corey Miller.
Thank you. All right, what are we doing?
Your Honor, Mr. Miller would like to have an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 14th. Preliminary examination in person, January 14th, 2025, 9 a.m. in person before Judge Valvo. Thank you.
Thank you.
Bond continued.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus DeAndre Mitchell.
Brian Bull, on behalf of Mr. Mitchell, state your name for the record.
DeAndre Mitchell.
Your Honor, we're asking this matter be set for an exam. I believe discovery to be complete.
People have their witnesses available the 14th. Preliminary examination in person, January 14th, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the People versus Antoine Patterson.
Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, Antoine Patterson. Your Honor, I have done everything to try to get a hold of my client, less a carrier pigeon. I have not been able to do so, unfortunately. I have reached out to prosecution in order to try and get an offer on this case. Still haven't heard from my client. That being said, I would ask for an adjournment. Am I asking for the wrong thing again?
We would object to that.
No, you're asking for the right thing. Deny. Bench warrant will issue for defense failure to appear. Bond will be set in the amount of $25,000 cashier.
Can we make it 10?
You want me to add 10?
No,
Okay,
less 15.
that warrant will enter me. Thank you.
Thank you. Have a good day.
Are you done?
I am.
Bye.
Welcome.
Wait till he leaves the room. Every court calls the case People versus Crystal Pratt. Sorry.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Pratt. Your Honor, I submitted a stipulation in order adjourning, which I believe was signed and I received back on Ms. Pratt's case.
Wait. It didn't get put into the file?
Yeah.
Did I sign it?
Yes.
Did I know Miss Apple was behind it?
Yes.
And I signed it?
Yeah.
Oh, okay. What day did we? adjourn?
I believe we adjourned it to the 23rd.
January 23rd,
Yes.
2025, 9 a.m. Bond continue.
Thank you.
Not a problem. Court calls the case People versus Thomas Rivera.
Pass the money for the people.
Right, well, you have to get.
You're seeking an adjournment.
That's accurate, Judge.
Probable cause conference, January 16th.
Thank you, Your Honor.
2025, 9 a.m. Continue. Court calls the case People versus Christopher Shedd.
Pass the money for the people. Assistant Public Defender Natalie Pate with and on behalf of Mr. Shedd, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Christopher Shedd.
You're looking for an adjournment regarding discussion of discovery.
Yes, Your Honor, our office has not yet received discovery, so we are requesting an adjournment to both.
January,
review it.
January 16th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir.
Thank you, Mr. Shedd.
Court calls the case People versus Joshua Steinke.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Steinke, who appears via Zoom. Sir, can you please unmute and state your full name for the court?
Yes, Joshua Steinke.
All right, I have before me a plea form that indicates that the defendant will be pleading no contest to 2 charges, count 4 being use of a controlled substance, that being cocaine, the 1-year offense. And then the count 5, attempted resisting and obstructing a police officer, that being a 1-year misdemeanor. Upon a successful no contest plea to, well, and also he's gonna plead to the stated count 2 of operating with the presence of a controlled substance. Upon his plea to those 3 charges. Right,
Yes, Your Honor.
counts 1 and 3 would be dismissed.
That is correct, Your Honor. The 2 felony counts, possession of a controlled substance, 4-year felony obstructing to be dismissed upon a successful plea. 2 counts, 2, 4, and 5. That is correct, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record.
Joshua Steinke.
Sir, it is this court's understanding that you're going to plead no contest to 3 misdemeanor charges. Is that correct?
Yes, Your Honor.
All right. It is first, the court's understanding you're going to plead no contest to the charge of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
It's also this court's understanding you're going to plead no contest to an added count 4 of use of a controlled substance, that being cocaine. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
Also, that you're pleading no contest to a charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things I have to make sure that you understand. The first thing you need to understand is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea in this case, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. And understanding all of that, well, the basis for the no contest plea.
Potential civil liability, Your Honor.
All right. And understanding all of that, you still wish to plead no contest. Is that correct, sir?
Yes, Your Honor.
To the charge of operating with the presence of a controlled substance, how do you plead?
No contest.
To the charge of use of cocaine, how do you plead?
No contest.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation or parole at the time of these offenses?
Yes.
Which one?
Which one, what, Your Honor?
Well, were you on probation or were you on at the time?
Probation, Your Honor.
All right, that's okay. Then you need to understand that your entry of your pleas in this case could be a violation of that probation. You understand that?
Yes, Your Honor.
If it is considered a violation of your probation, then that other court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, Your Honor.
All right. And understanding that, do you still wish to plead no contest to these charges?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will.
Yes.
Counsel, the court has been invited and has reviewed Eastern Michigan University Police Department report for their case number 24912. Any objections to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant guilty of these offenses. Counsel, have I complied with the court?
Please satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest to counts 2, 4, and 5. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B District Court. Sentencing in this case will be
February 13th at 10 a.m. before Judge Washington.
February 13th, 2025, 10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank
Thank
you, Your
you.
Honor. Thank
Thank
you,
you.
Mr. Steinke. You're all set for today.
Thank you.
Court calls the case, People versus James Townsend.
People,
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Townsend. Please say your name for the record.
Good morning, James Townsend.
Your Honor, we are asking that this matter be set for a preliminary examination.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available the 14th.
I regard that date, Your Honor. Thank you.
Preliminary examination in person, January 14th, 2025. 9 a.m. before Judge Falvo.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Anthony Turner.
Assistant Public Defender Natalie Pate on behalf of, and not with unless he is on Zoom, Mr. Anthony Turner.
Negative.
Your Honor, I do not have an explanation for his failure to appear. The couple numbers I did have for him were both disconnected. I did not have an email address for him, so I do not have an explanation for his whereabouts. For the record, I would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond set amount of 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case of the People versus Alan Ward.
After one of the people,
Good afternoon, Your Honor. Assistant Defender Constable Lacey on behalf of Mr. Alan Ward, who is approaching to my right. Ward, could you go ahead and state your full name for the record? Alan Ward.
All right. I have before me a plea form that indicates pleading no contest to an added count 2 of attempted resisting and obstructing a police officer. The 1-year offense. Upon a successful plea, count 1 would be dismissed. Further, it indicates no delayed or deferred.
that is a presentation of our agreement. Your Honor. Thank you.
That is correct, Your Honor.
May I have this form?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Alan Ward.
All right, sir, it is this court's understanding that you're going to be pleading no contest to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it, just to make sure. It means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Basis for the no contest plea.
So, lack of recollection, Your Honor.
So understanding all of that, sir, still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
Pardon?
No contest.
All right. Now you understand that you will not have a trial of any kind.
Yes, sir.
Have you signed any advice to rights form?
He hasn't signed it, but we did review it, Your Honor. He
Signed. You're sitting there for like an hour. I'll wait.
Okay.
I have to.
I might need a new one, actually. Same one.
Oh, you didn't even have the form?
No, I had one.
Man,
I just
go,
wrote some
just
notes.
go.
I just wrote
Just,
some notes
just
on it.
hurry up. And all these people are waiting. This is why my day takes so long. He was sitting right there.
Isn't this second to last
Last, like,
case?
4 hours. He handled 2 cases. Okay. And this one just. Yeah. Anyway, sir, you now signed an advice of rights form. Do you have any questions regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are a part of the trial. You understand that pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal over.
Yes, sir.
Are you on probation or parole? Anybody promise you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 23-400. Any objection to the court having reviewed that report?
None from the people.
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
People are
The
satisfied.
defense is also satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count two, count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be January 29th, 2025, 1 p.m. And that is before me. All right. Bond will continue.
But you were before Judge Simmons, or?
You wanna know what, man? Don't make me come up with. No. Thank you. Sir, on your way out, down on the left is our probation department. Stop in there and check in. And that way they'll get the process started. All right? Thank you. Court does call the case People versus Levante, Washington.
Public Defender Natalie Tate with and on behalf of Washington, who is approaching the podium. Please state your name for the record, sir.
Levante, Washington.
Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we also willing to address that one, wherever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 12/27 and 12/30 for cocaine. He did already send out the 12/27 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on after court today appearing in Community Corrections to have his recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that that be addressed at that time.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite a possibility. He's staying on top of this, continued to test even after he did get that positive result. Community Corrections and paid $3 to have that sent out.
You gonna have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today, I get those results immediately. Is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything. I don't know. But if we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. Courtroom.
Ma'am, are you a whore?
So
I object to the
did you?
relevance of
recover
that, Your
progress
Honor.
report?
All
right, what?
I'll tie it up
Yeah,
real
'cause
quick,
I'm
Judge.
getting a lot of.
All right, go ahead.
Beepers.
You're not a
Yes, I
whore?
did read it.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at community corrections, said, I smoked it around him. That must be how he's testing positive. You believe that?
That's,
You believe, hold on, no. You believe that?
yes, Your Honor.
Really?
That's the truth. I got
Council
two on the line.
Pro, you might want to just be quiet because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Council approach.
There shall not be any cutting of trees. Don't cut any trees. I'll pass the order. No cutting of trees, no felling of trees in Patna number 12.
Yeah, the Wi-Fi is rough. Like anything I do takes 30 seconds to happen here.
The wheels of justice are going to roll you right into the Wayne County Jail.
Lucinda. Anything else you want to say?
Nothing.
Yeah, I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address that at that time, if in fact the lab confirms that it was a positive result. I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court
I'm
date.
not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days at least in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
May I approach on an unrelated matter?
You may.
Thank you.
what you've heard. Legal logic hit the ground, round and round, lost and found. I'm just a sovereign idiot. My defense will fail spectacularly. To be guilty is not my style. Arguing laws that ain't worthwhile. In the courtroom standing proud, in a fog but being loud. Pointless battles in my head, stuck in rules I don't understand. In the courtroom standing proud, in a fog but being loud. Pointless battles in my head, stuck in rules I don't understand. In the courtroom standing proud, in a fog but being loud. Pointless battles in my head, stuck in rules I don't understand. On the highway claiming free, no power over me, says my plea. I'm a sovereign in denial, gonna be here for a while. Cause this life sentence takes a seat, my arguments are obsolete. Just a fool in legal night, trying hard to win the fight. I'm just a sovereign idiot. My defense will fail spectacularly. To be guilty is not my style. Arguing laws that ain't worthwhile. I object to every word. No sense. Number one, know what I'm saying? Number one, know what I'm saying? We are the Law Talk with my crew. Number one, know what I'm saying? 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 Number one.
Jack it up.
scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pre-trial on the dial. Planning always make your chap smile. The pro say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing heart. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never going soft. Webster is always showing hard. We are heading into. There is no scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pre-trial on the dial. Planning always make your chap smile. The pro.
Any objection, Mr. Miller?
I actually object to everything he's doing.
I'm sorry.
That's Windsor. But you know, my favorite sport, what we. She covered the coins. State was in jail. We were talking.
All rise. 14A District Court for County of Washington, State of Michigan is now back in session. Judge J. Cedric Simpson presiding.
May be seated.
I really don't.
At the fear of it maybe wanting to cause some embarrassment. Ms. Zenda, congratulations. Ladies and gentlemen, this, I guess, is our newest APA for Washtenaw County.
That's
It's
correct.
here for me, and it was a pleasure having you here. I wondered why you were just sitting over there doing nothing today. But I thought it was because I think you were on a grant position before. And I said, okay, there's nothing that fits the grant. So I'll let her sit there. I won't pick on her. But now that I know that you're like official, game on. But congratulations, young lady. It's good to see Washtenaw County makes good choices. So, and thank you for Miss Lundy for informing me, because none of these other people were going to tell me.
You're welcome, Your Honor.
Or does come case of the people versus mandates.
Andrew Chilton. Assistant Public Defender Ben Dunaway on behalf of Mr. Davis on both cases. Mr. Davis is just approaching the podium now, Your Honor. I believe Mr. Davis is going to waive exam on the case ending in 555, and the people are not prepared to proceed on the other case. If you do want to waive, you can sign.
He's going to waive on 1555.
Yes, Your Honor, he is signing the form right now. May I approach the clerk of the court with the form?
Sure, my bailiff. Your name, sir?
Man,
Thank you.
how you doing, Cedric?
I'm doing great, Mr. How you
You should be
doing?
on first name basis by now, man. Yeah.
Well, no, we ain't going there.
We ain't there yet?
Right?
We see each other 5 times in a week, man. You know, we friends.
Well, see, that's your fault. It's not mine.
Yeah.
All right. On case 1555, you're waiving your right to a preliminary examination.
Yes, Your Honor.
All right. You understand that that's a proceeding which was to occur today. In which the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes.
All right. You understand you'll not have that hearing proceed to circuit court for further resolution on this case.
Yes, Your Honor.
All right. People also waive the right. Yes, sir. Preliminary examination, having been waived, defendant is bound over to circuit court on count 1. with count 2 following.
Thank you, Judge. I believe on the other case, the people are not prepared.
Turn on this.
Oh, we have the formal reading, stand mute.
Pending every way formal reading, standing mute, court will enter a not guilty plea as counts. Pretrial will be set for January 15th, 2025, 1:30 before Judge Conlon.
Oh. Oh,
You don't need to raise your hand, but go ahead.
Well,
But
I supposed to be in front of you on the 15th. Sentencing at like 12, I think, or something.
at 12,
Yeah, I think so. Or 1.
what? Time blocks aren't out yet, so he doesn't know. He's just, well, he's in custody. So if he's in custody, it's gonna be earlier. We'll get you out in time.
All right,
All right, otherwise I'll call Judge Conlon and let him know we have you
all right.
for a little bit, all right? All right, in that case, bond will continue. And on the other matter,
Today's date time set for the preliminary examination. This time the people are unable to proceed.
Defense moves to dismiss.
people being unable to proceed, case is dismissed without prejudice.
Thank you, Your Honor.
All right, thank you. So Davis, we'll see you next time around. Yes, sir. Let's see. Probation. Court calls the case of the people versus McKinnon, Washington.
Ready on it. Nicole Hughes on behalf of the people.
And good afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mikey on Washington, who is now standing at the podium. If you could state your name for the record, please.
Mikey Harley.
And Your Honor, so we submitted a green sheet in this one, which was unexpected. I got a call very late last night. Mr. Vincent has that norovirus where it's just the worst stomach flu can be imagined. Picked this file up this morning on my way in. But we're asking for a very short adjournment for that reason. I believe the people don't have an objection to it, as stated.
Vincent?
Yep.
I don't believe it. He just didn't want to.
If you don't believe it, Your Honor, you can invite him up here, but I had this thing 3 weeks ago. It's a dangerous thing to go out in public with.
I don't believe it. Just think Vincent didn't want to see me today. I was sitting there last night thinking I gotta see Simpson in the morning. Ow, my stomach hurt.
You know, Judge, for my money, I probably didn't want to see me either.
I really did. I realized not many choices.
It's lose-lose.
All right. Well, given that, adjourn it, when's my next?
21st.
21st. I think he's got other things.
He does, Your Honor, so that's perfect.
All right, I'll adjourn the preliminary examination in person, January 21st, 2025.
We appreciate it.
9 a.m. before me.
Oh.
And we'll.
Thank you, Your Honor.
Please. Although we joke about it, tell Mr. Benson I hope he's.
I sure will. You'll see you next week, Judge. Take care.
Court calls case people versus Cia Collins.
Absolutely, the people.
Goldstein appearing on behalf of the defendant.
Big time set for preliminary examination. This time people are unable to proceed.
We have no objection to a dismissal, Your Honor.
People being unable to proceed, this case is dismissed on the defendant's motion without prejudice. All right, thank you. Thank you, Mr. Collins. Court calls case people versus Jonathan DeHaze.
Absolutely, the people.
Good afternoon, Your Honor. James Sullivan for John DeHaze State.
Jonathan DeHaze, thank you. You're waiving.
Yes, Your Honor.
All right, sir, is that correct? Yes, sir. You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense, excuse me, alleged was committed and she committed it. Yes, sir. You understand you'll not have that here and you'll proceed to circuit court for further resolution. Yes, sir. People also waive their
You know,
preliminary examination have been waived. Defendant is bound over to circuit court on a single count. Counsel, you acknowledge receipt of the information and waive the treaty,
Yes, Your Honor.
and your client stands muted.
Yes.
Defendant waive for reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for.
February 24th at 1:30 for judgment.
Who?
Sorry, you said February. 24th?
Hamoud? How's that spelled? I know how to spell it. Got it. February 24th, 2025, 1:30 before Judge Hamoud.
Thank you.
You said Judge who? Judge what? What was the judge's name? Oh, no, it's Janan Hamoud. Thank you, sir. Brand new, but we are awful proud of her. Grateful to have her on the bench. So,
No other issues from the people here, may I approach with any information?
yes, bond will continue. Thank you. I think I spelled the name wrong. Calls case, People versus Abney Willis.
Absolutely, people.
Alex Warren Green on behalf of Mr. Willis. Mr. Willis, are you present?
And Mr. Willis is in federal custody. It's not clear whether or not a writ was requested, but we do know that Mr. Willis, in order to appear via video conferencing, would have to participate with a program called WebEx, would not be able to use Zoom. There's lots of things happening here. Suffice it to say, though, Mr. Warren Green and I have discussed this case and have come to what we both think will be an agreeable resolution. So we are jointly requesting an adjournment for maybe 4 weeks or so, whatever the court can accommodate, to allow Mr. Warren Green to have time to speak with the defendant about the resolution. And Mr. Warren Green has further agreed that at the adjourned date, because my victim was present today, that person would not need to reappear next time in anticipation of a plea.
Got
If
it.
does not go forward, we would come up with a different date to have that person come.
That's correct, Your Honor. And the last time our office spoke with Mr. Willis was at the time of arraignment. That's when we came to learn that the federal facility uses WebEx.
Right.
I haven't personally spoken to this client, but it is my understanding at the time of arraignment, he was resolution oriented. So I anticipate that we may be able to resolve this at a later date. I am completing a green sheet that I will provide to the court.
Well, why don't, would February 11th be about, but we give you enough time?
Yes, I believe so, Your Honor.
All right. February 11th, 2025, 9 a.m. For me.
Thank you so much, Your Honor.
Thank you, Your Honor.
That goes with that's the felony case and also the misdemeanor, which is tracking with.
And our resolution does contemplate both cases.
Mhm.
Yeah, okay, great.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Daniel Magoo.
Absolutely.
It's happening, people. I have to say, I lost faith.
Daniel Magoo.
Ready for preliminary examination or motions? What are we doing?
Yeah, with the court so kind as to make the self-representation inquiry, and
Yes.
perhaps we could look at the motion first.
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony, punishable by up to 2 years incarceration, $2,000 fine. Court call. You appear here unrepresented as you have in the past, and the court has given admonishment regarding self-representation. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings, you decide that you wish to be represented by counsel, cannot afford to hire counsel, then the attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right,
Thank you.
what are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, yeah.
All right.
Sorry.
Their response from the people regarding that.
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state. And I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do. Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his phone. I will note, I'm just seeing today, it looks like the defendant may have a MacBook, and I know that those can have a little bit more difficult time with some of the audio files that come from my office, so that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of,
I believe the 911 call that brought the officers to the scene, but it would not be an exhibit that people plan on playing at the preliminary examination.
all right.
I would like then to motion for a preliminary examination to get the officers and you on the record then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
Oh, Your Honor.
All right. With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate, does not see an abuse of discretion regarding that. With reference to, the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter. And would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for Your Honor.
Yes. So preliminary examination will be set January 21st. 2025, 9 a.m. before me. That's in person. Attendance bond with conditions is continued.
Oh, good Lord. I streamed for an hour and a half, and then we have the only reasonable appearance that this Joker ever had in his life. What are you going to do? What are you going to do? I'm just waiting for him to freak out on the way out or something. It's not going to happen.
They're all in here. Or you got them.
Thank you. Well, there you have it. Some days that's the way it goes. And it wasn't just this stream. I did 2 streams. Although the first one I saved with plan B. This one was mostly listening to music and reading the word private. Oh, there you have it. All right, fine. Whatever. I'll get my nap now. Thanks for coming out. We'll have better days. See y'all soon.